Parole Evidence Rule Part 3, Integration. As we discussed in the first module, the PER only applies to written agreements. However, it does not necessarily apply to all written agreements, and it applies to written agreements differently depending on their level of integration. The second restatement, section 209, subsection 1, defines an integrated writing as a final expression of one or more terms of an agreement. So a draft circulated during negotiations before agreement is reached is unintegrated. It is not the final expression of any agreement. If a writing is unintegrated, there is no PER issue. By definition, there's no final written agreement, and any extrinsic evidence is admissible to establish whether the parties had an oral agreement, and if so, what its terms are. Of course, an unintegrated writing might create a statute of frauds problem, but that's a different issue. At the other end of the spectrum is a completely integrated agreement, sometimes referred to as total integration. Restatement section 210, subsection 1, defines a completely integrated agreement as one adopted by the parties as a complete and exclusive statement of the terms of the agreement. If a writing is a completely integrated agreement, then any extrinsic evidence, prior or contemporaneous, to contradict or add new terms is inadmissible. In between unintegrated writings and completely integrated agreements are partially integrated agreements. A partial integration includes some, but not all of the terms on which the parties have come to an agreement. If a writing is a partial integration, then extrinsic evidence, prior or contemporaneous, is not admissible to contradict any of the terms set out in the writing, but evidence of a consistent additional term is admissible to supplement the writing. See Restatement sections 215 and 216. According to Restatement sections 209 and 210, whether or not a writing is integrated and whether it is partially or completely integrated are questions of law for the judge. So how does a judge determine integration? Just as with the question of ambiguity, there are a range of possible methods for a judge to use. At one end of the spectrum, there is the four corners rule. This rule is similar to the plain meaning rule used by some judges to determine ambiguity. And under it, the judge would determine the level of integration from the writing itself. She would limit her inquiry to the four corners of the document. As with the plain meaning rule, the four corners rule has been criticized for ignoring the context in which the writing was drafted. According to the second restatement, the more modern approach is to consider all of the evidence prior to determining the integration of a writing. Section 214 states, one particularly tricky area concerning integration arises when one party to a written agreement alleges that the parties had an oral side agreement. For example, in an old case, a buyer entered into a written land sales contract according to which she promised to pay $8,000 for a piece of land. Let's call it Parcel A. Now, there was an ice house on an adjoining piece of land, Parcel B, that interfered with the view from Parcel A. It turned out that the sellers owned the ice house, and according to the buyer, they agreed to remove it from Parcel B. But this agreement was oral. Let's start from the obvious. The land sales contract signed by both parties is an integrated agreement. Whether it is partially or completely integrated remains to be seen. If we analyze this case under the second restatement, the actual case predated it, the first point to consider is that Section 215 states that extrinsic evidence cannot contradict the terms of an integrated agreement. And this is true regardless whether the agreement is partially or completely integrated. So, does an oral agreement to remove the ice house contradict a term in the written land sales contract? The answer depends on how you look at it. The sellers could argue that the land sales contract states that the consideration for the purchase of parcel A is $8,000. The buyer is now saying that the consideration was $8,000 plus the removal of the ice house, and that contradicts the written consideration term. The buyer could argue that the land sales contract referred to the price in money for the purchase of parcel A, and that price was $8,000. The removal of the ice house from parcel B was not a part of the money price. It was an additional promise the sellers made to induce the buyer to purchase the property. That would not be a contradiction, just a consistent additional term. Let's say the buyer wins this argument, and the judge concludes removing the ice house does not contradict anything in the land sales contract. We are not yet done. Recall that under Section 216, if the writing is partially integrated, a party may introduce evidence of a consistent additional term, whereas if the writing is completely integrated, a party cannot introduce such evidence. Moreover, and this is the tricky part, according to Section 216, subsection 2, the court can consider the alleged additional term in deciding whether the writing is completely or partially integrated. If the alleged additional term is one which in circumstances might naturally be omitted from the writing, then the writing is only partially integrated and the evidence of the additional term is admissible. The implied converse of this is, if the alleged additional term is one which under the circumstances would not naturally be omitted from the writing, then the writing should be considered completely integrated and evidence of the additional term should not be admitted. Returning to the ice house case, is the alleged term that the ice house will be removed from parcel B one that, under the circumstances, would naturally be omitted from the written land sales contract? Again, the answer depends on how the judge frames the scope of the written agreement. If the judge thinks the land sales contract encompasses everything having to do with the buyer's purchase of the land, then she would probably conclude that the removal of the ice house, being an important part of the deal to the buyer, would have been included in the written contract. Because it wasn't, she would not admit evidence regarding it. Conversely, if the judge views the land sales contract as simply relating to parcel A, then she could conclude that the parties might have naturally omitted something relating exclusively to parcel B, that is, the removal of the ice house. Since the parties have naturally omitted the provision from the written contract, she would admit evidence regarding it. Keep in mind that all the judge is doing is letting the evidence come in. Ultimately, it will be up to the fact finder to determine whether or not the parties really had an agreement about removing the ice house. It is possible that the judge rules the evidence is admissible, the buyer takes the stand and testifies that the sellers agreed to remove the ice house, and nevertheless the jury doesn't believe her.